Hi everyone, this is Pennsylvania attorney Evan Gutman presenting video number 10 of my legal education series regarding the good moral character requirement to obtain a law license. The series is based upon my book, State Bar Admissions and the Bootlegger's Son. The full book is included on my two websites, one of which is entitled heavensadmissions.com and the other is gutmanvaluations.com. The full book, along with the supplement I wrote, is currently available on both websites, along with a fictional novel I wrote titled Heaven's Admissions Process, which compares the criteria for being admitted into heaven in a somewhat humorous and comical manner. It's a fictional novel with the criteria for becoming a lawyer regarding the good moral character requirement. So all my videos have a PDF associated with them. You should be able to access it. If for any reason you can't access it in looking at this video, you can access it on both of the websites, heavensadmissions.com and gutmanvaluations.com. So here we go with video number 10. In video number 9, I examined how the state bar admissions process really works regarding the good moral character requirement for admission. Now, in this video, I'm going to examine the assessment as to whether the state bar's good moral character requirement for admission has been successful or unsuccessful. And it is my position that the good moral character requirement for admission to obtain a law license has been a complete, total, abject failure. It's been, as examined in previous videos, it's been approximately 90 years since the National Conference of Bar Examiners in 1931, basically, began their process of the good moral character requirement for admission. Prior to that, it was done on a very haphazard basis. It became more formalized under the NCBE, National Conference of Bar Examiners. My position is that the good moral character requirement for admission to obtain a law license was designed really only to enhance the economic interests of attorneys while simultaneously promoting racism and subjective assessment of good moral character. In the early years, for the most part, people who were denied admission to the bar on the grounds that they lacked good moral character were Black, immigrants, Jewish, or women. That's pretty much the way it worked. If you were in those categories, you quite often were determined to not have good moral character based upon simply the manner in which you were born. In 1957, in the Königsberg case, and that's cited in my book, responding to pervasive McCarthyism that still thrives in state bars today, the U.S. Supreme Court wrote as follows in Königsberg versus State Bar of California regarding good moral character. Quote, "It can be defined in almost unlimited number of ways, for any definition will necessarily reflect the attitudes, experiences, and prejudices of the definer. Such a vague qualification, which is easily adapted to fit personal views and predilections, can be a, quote, dangerous instrument for arbitrary and discriminatory denial of the right to practice law." And that's the crux of it, really. Basically, once you have subjective assessment of good moral character, instead of it being based upon objective conduct, the assessment of good moral character becomes a, quote, dangerous instrument, unquote, in accordance with the U.S. Supreme Court's Königsberg case, which, by the way, this is one of the few times I agree with the U.S. Supreme Court, because I do believe that's a very accurate assessment. The operative phrase is dangerous instrument. Historically, the state bars refused to heed that warning of the U.S. Supreme Court, and they've done exactly what the court has warned them not to do. They use the good moral character standard as their fulcrum for arbitrary denial of a law license when faced with an applicant who does not support their financial interests or irrational political and societal beliefs. Applicants are regularly denied admission by ludicrous bar committees for being glib, facetious, arrogant, flippant, and a wide host of other mere personality traits totally unrelated to whether they've ever violated the law or not. Just because they don't like their attitude, they don't like how they look, they don't like how they seem, they don't like what they say, they don't like the manner in which they speak. The best evidence of the failure of the good moral character standard for denial of a law license really rests in the opinions of the general public. Since the NCBE's, National Conference of Bar Examiners, inception in the early 1930s, the general public's view of attorneys, so far as I know, really hasn't improved all that much. The typical non-attorneys tend to view the legal profession as being comprised of deceptive, slimy, cheats, crooks, and scoundrels. That's not really representative of good moral character if the general public believes these people don't have good moral character. Look at other professions. Doctors, engineers, accountants, architects, and in fact, even used car salesmen are generally regarded by the general public as having better moral character than attorneys. No profession is viewed more contemptibly than the legal profession. That alone demonstrates that the so-called good moral character standard, which no other profession is subject to in the manner in which they are with respect to attorneys, has been a complete, total, abject failure. Appellate opinions consistently, falsely characterize the legal profession. Appellate opinions consistently characterize the legal profession as a, quote, learned profession, a time-honored profession, a respectable profession. By doing so, they themselves, those appellate courts, fail the good moral character standard because such false assertions falsely disclose the true nature of the legal profession. The legal profession historically has never been well regarded. It is actually quite often compared to prostitution. The legal profession is quite often compared to prostitution and not even viewed as favorably as that also, quote, time-honored profession. And that is a time-honored profession. Even those individuals who become lawyers and pass the character review become embittered by the process. They become embittered by the process, by the questions they were asked. The state bars, the assessment of moral character, the legal profession and the judiciary have in fact alienated their only possible supporters. The lawyers such as myself who passed the character standards but became embittered by the process that required them to do so in becoming an attorney. I hope you enjoyed today's video. We'll have the next one either in a day or two or a few. I'm not exactly sure how many it's going to be, but hope you enjoyed it. And remember, love right, don't fight. Bye.